Hello and welcome to our CLAT tutorial, and we will start with Introduction to Constitutional Law. I am Dr. Manvendra Kumar Tiwari, and I am an associate professor at the Dharmashastra National Law University, Jabalpur. Starting with, we'll give a brief introduction about some of the key principles of Constitution. To start with, we have the first principle of constitutionalism. Constitutionalism, as you can see here, it is a principle which is aspirational. Though it is derived from the constitution and political tradition, but over the period of time, the principle has become so important that in the absence of constitutionalism, we say that a constitution ceases to be constitution. What it provides for. What do we mean when we say constitution? Constitutionalism is the limitation on the powers of the state. That is, if there is a constitution, it must ensure that the powers of the state are limited and not absolute. We have three organs of state primarily: legislature, executive, and the judiciary. However, there is another organ of state which is being increasingly discussed these days, which we call as guarantor institutions or integrity institutions, or the fourth organ. We'll come to it one by one. Now, why are we talking about the organs of state? Because it is through the organs of state that the state exercises its powers and functions. However, the fact that the state has been bifurcated into various organs ensures what is called the institutional check and balance theory, which we also know as the concept of separation of powers. So separation of power is actually central to the idea of constitutionalism, whereby one organ of the state, apart from performing its functions, also ensures that the other organ of the state remain within the constitutional bounds of its power, and that this function of keeping the other organs within check is also the function attributed to a particular organ of the state. And this is how the constitutionalism comes to play, whereby the organs of the state ensure that apart from performing their own functions, they are also ensuring that the other organs of the state remain within the bounds of the constitution. As constitution is a living concept, so is constitutionalism. So it has to be alive and kicking at all points of time. And that is why we call it a living concept, because it keeps on unfolding every single day in the life of a given polity. A term, though we say that constitutionalism is derived from constitution, but at the same time, we must know what is a constitution. So a constitution is the supreme law of the land, which, apart from laying down the limitations on the exercise of sovereign power by the state, also provides for the fundamental structure of any given polity. A constitution, as it is popularly understood, a constitution can be written, as is the case with the Constitution of India. Constitution of India is a very detailed constitution, running into 395 articles and 8 schedules. And we now have 12 schedules, 4 schedules having been added by way of constitutional amendments. Apart from that, there is also something called unwritten constitution, and invariably when we talk about unwritten constitution, we refer to the English Constitution as an example of unwritten constitution. However, it must be understood that to say that United Kingdom as an unwritten constitution is not in its entirety true, because most of the constitutional principles are actually in the form of written legislative provisions existing in United Kingdom. So why do we call it unwritten? We call it unwritten constitution primarily because of the fact that, unlike a formal document that we know and understand as constitution, United Kingdom does not have a formal legal document called constitution. Uh, Primarily because no such need ever arose in United Kingdom for a formal constitution to be drafted. As we know that constitutions are also product of time, in the sense that it is owing to the particular history of a given state that constitutions come into existence. There is always that epochal founding moment when when the founders of any given polity who want to embark on a new journey would like to have their own constitution to start. No such situation arose in United Kingdom because of its own peculiar history, and that is why United Kingdom continued with its tradition of legislations being supreme, and parliamentary sovereignty is something that is the ultimate authority so far as United Kingdom is concerned. And through the exercise of legislative power of the Parliament, the UK Parliament has laid down several fundamental legislations, and those legislations collectively actually provide for the constitution of the United Kingdom. So, though unwritten in the sense that they do not have a formal constitution, but at the same time, most of the constitutional provisions are actually enshrined in various fundamental legislations of the United Kingdom. So, in that sense, it's a mixture of both in the sense that they do not have a formal constitution, and yet they have legislations which have acquired the stature of actually laying down constitutional principles. Such can also be the case when it comes to constitutions. As I said, set of rules, principles to govern a country. Fundamental rules, these are, because the rules are contained in other legal documents as well. But this is something which is fundamental and supreme, and it lays down the fundamental structure of a given polity. We'll move on to this definition of constitutionalism, and this comes from a judgment of the Supreme Court of India as delivered in I.R. Coelho versus State of Tamil Nadu. What is constitutionalism? Constitutionalism, the Supreme Court in this case said, is now a legal principle which requires control over the exercise of governmental power. As I said in my introduction to constitutionalism, to ensure that it does not destroy the democratic principles upon which it is based. These democratic principles include the protection of fundamental rights. The principle of constitutionalism advocates a check and balance model of separation of powers. It requires a diffusion of powers, necessitating different independent centers of decision making. So one important thing that we haven't so far discussed as part of constitutionalism, which this observation of the Supreme Court is telling us, is the protection of fundamental rights, which acts as a pivot for ensuring that constitutionalism remains a living concept. Because the separation of power theory is modeled on the structure of fundamental rights, in the sense that the organs of the state, namely the legislature and the executive, while acting, have to compulsorily ensure that they remain faithful to the idea of fundamental rights. And whether their actions have transgressed fundamental rights or not, these questions are to be determined by an independent judiciary. So in that sense, the fundamental rights remain the pivot around which the constitutional separation of power model, through its checks and balances, operates under the Constitution of India. As I said, separation of powers is one of the fundamental principles which ensures constitutionalism at play. So we have the organs of state, namely the legislature, the executive, and the judiciary, and the fourth organ, that is the integrity or guarantor institutions. And examples of these institutions are Election Commission of India, Comptroller and Auditor General of India, and Lokpal. Very briefly, I'll let you know as to what primarily are the functions of these organs of the state. Now, legislature is supposed to legislate. Legislation is the act of making law. So, in contemporary era, legislation is the most modern and intentional, voluntary act of lawmaking, and it exhibits democratic mandate of the given legislature to enact a law, and therefore legislature has been empowered to make laws. Apart from legislature, we have executive. The primary function of the executive is to implement the laws made. And then we have the independent judiciary. Independent because in say, for example, the Indian parliamentary model of governance, there is a fusion of legislature and the executive, in the sense that the cabinet will always comprise of people who are members of the legislature. It is a compulsory constitutional requirement. So in that sense, there is a fusion of legislature and executive. Therefore, legislature is not independent of executive in its entirety, and vice versa. Executive is not in its entirety independent of the legislature. And therefore, both these bodies consist primarily, not primarily in its entirety, of politicians. And politicians may have their own political interest further, and therefore their actions may at times derogate from the constitutional provisions and constitutional principles. And therefore, to guard against such eventuality, we have the organ of independent judiciary. Independent in the sense that it is independent from the legislature and the executive, so that it can impartially and independently perform its function of keeping an oversight over the executive and the legislature. So, however, despite the fact that we have the fusion of legislature and executive in the parliamentary form of government, nevertheless, according to the Constitution of India, executive is accountable to the legislature, and the legislative accountability is ensured ensured by the legislative oversight over the executive. And legislature is not only consisting of the members of the ruling political party or political coalition. So in that sense, the legislature also has the oversight role over the executive, and both legislature and executive are subject to the oversight of an independent judiciary. Apart from these three primary organs of the state, these days, as I said, there has been increasing discussion about the fourth organ of the state, also referred to as integrity or the guarantor institutions. Now, Election Commission of India, for example, consists of bureaucrats who are actually drawn from civil service. So technically, they are also part of the executive. So in the sense that they are also part of the same bureaucracy. However, they don't act under the command of the executive. So that makes them independent. The fact that they are not working under the command of the executive means that they are independent of the executive. So in that sense, it is a fourth organ. Like is the case with Comptroller and Auditor General of India, it is again maybe actually being manned by people who come from civil service. So again, forming part of the executive. But the functions of the Comptroller and Auditor General are such that it has to keep an oversight over the executive's power of spending. And in that sense, it is it is an organ independent, it is a body independent of the executive. Okay, so we have this unique set of organs where, despite the fact that the people may actually come from the same pool from where the people from executive actually come, nevertheless, owing to the functions which they perform, which includes being an oversight over the executive, these integrity or guarantor institutions are not clubbed as executive, rather, they are understood as part of the fourth organ of the state. So, this is how separation of power is at play. And as I said, separation of power is the pivot which ensures that constitutionalism is at play, that the powers of the state are not absolute, and there is an institutional check and balance that is existing in any given system. Now, we'll come to rule of law after this. Rule of law is also an associated concept associated with the concept of constitutionalism. What rule of law means? So as you can see, this is coming from judgment of the Supreme Court, where the Supreme Court has quoted a British jurist, Professor A.V. Dicey, whose definition of what is meant by rule of law is often relied upon, just to have a theoretical understanding of what is rule of law. The rule of law means the following. First, absence of arbitrary power. So there has to be absence of arbitrary power. And this power is mainly, when we say power, it's mainly attributable to a state. However, anyone exercising arbitrary power is actually acting contrary to the mandate of the rule of law. And the second aspect is equality before law, or the equal subjection of all classes to ordinary law of the land administered by ordinary courts. So its second aspect is equality before law. And this equality is ensured by equal subjection of all classes to the ordinary laws of the land, which are actually administered by the court. So that means people of any given polity are subject to the ordinary laws of the land, which are actually implemented by the executive, nevertheless interpreted and applied by ordinary law courts. So this is also one very important aspect of rule of law. And the third aspect is that the Constitution is not the source, but the consequence of rights of individuals as defined and enforced by the courts. This is another important aspect, that the source of right in the given polity is not the Constitution. Rather, Constitution is the consequence of the existence of rights. That means Constitution exists for the rights, and rights do not actually flow from the Constitution. This will ensure that rights would remain forever, because rights are not the creation of Constitution. Rights pre-existed Constitution. So this idea has to be there in any system of rule of law. And the rights are to be defined and enforced by the courts, not by the executive or the legislature. That means, again, an independent judiciary must be there to ensure that the rights are interpreted and enforced. If these attributes are present, we say that a society or a given polity has the element of rule of law present in it, which is very, very important for any system to be recognized as civilized system. Now, we'll come to fundamental rights, not individual fundamental rights, but about the concept of fundamental right and what it means to have fundamental rights. Again, this is something that flows from the idea of constitutionalism, because separation of power, the access for the actions of the government remains the fundamental rights as provided in the Constitution of India. So as you can see, fundamental rights are actually provided in Articles 14 to 32 of the Constitution of India, and 32 and 226. These two articles are actually provisions of the Constitution of India, which give the authority to Supreme Court under Article 32 and the High Courts under Article 226 to enforce the fundamental rights. What do we mean by that? And this enforcement is possible by way of directions, orders, or writs. So we'll understand this one by one. And we'll not right now individually go into the fundamental rights. Nevertheless, one thing that we must know is that Article 32, which provides for the Supreme Court to have the right of enforcement of fundamental rights, this itself is also a fundamental right, unlike Article 226, which is not in itself a fundamental right. Moving to now, fundamental rights are primarily available against the state, and the state has been defined under Article 12. It includes, again, the legislature, the executive, and the instrumentalities of the state. One important omission is the judiciary. Judiciary, though, is a state, but for the purposes of Article 12 and for the purposes of fundamental right, it is not state. That means, though an order of judiciary, if it is wrong, which has a bearing on fundamental right, then that order may have actually violated fundamental rights. But because of the peculiar nature of the function which the courts perform, that is to interpret, there is always a likelihood of an interpretation being subsequently recognized as flawed. And that is why a cushion has been provided to the courts so that they can independently, without fear, interpret the constitutional provisions, including the fundamental right, whereby they have been kept out of the purview of Article 12. So nobody can raise a plea that an order of the court has actually violated fundamental rights, despite the fact that this may actually be true. Now coming to other aspects of fundamental rights, Article 13. Now this is a very, very important provision. It provides for the basis of fundamental rights against the laws made, because it says that no law can be made which is contrary to fundamental right. It says that if there is a law that is contrary to or in violation of the fundamental rights provided in the Constitution, then in that case the law is void. Okay. Now this is one very important provision which, when read along with Article 226 and Article 32 of the Constitution of India, gives High Courts and the Supreme Court the power of judicial review of legislation. As per the power of judicial review of legislation, a legislation can be challenged before High Courts and Supreme Court on the ground that a given legislation or a legislative provision or more than one legislative provision is actually in violation of the fundamental rights. And if it is proven before the High Courts and Supreme Court where such a plea is raised, the law which is violating the provisions of fundamental right or any part of that law or that part ceases to be law, in the sense that that part of the law becomes void. So, and the duty to evaluate or to adjudicate such question lies with High Courts and Supreme Court. This is an important function because, like United Kingdom is one's country where no such exercise is done. That is, courts do not determine whether a particular law is consistent with the fundamental rights or not. However, of late, after the passage of Human Rights Act 1998 in United Kingdom, UK courts do decide whether a given law of United Kingdom is actually consistent with the provisions of European Convention on Human Rights or not. This is, as you can see, is a very later development. Till 1998, they had no such mechanism whereby whether a law is correct or not, that will be examined. Whereas in India, right from 1950, we have this mechanism whereby the legality or the constitutionality of a law can actually be examined on the basis that it is consistent or inconsistent with the fundamental rights provided. And the source for such exercise comes from Article 13. Article 13, if we look at it, Article 13, Clause 1, it covers pre-constitutional laws. Pre-constitutional because uh, under our Constitution, the laws that were operating and existing at the time when the Constitution commenced, those laws also continued to operate even after the passage of the Constitution. Article 13.1 says that even those pre-constitutional laws are valid to the extent they are consistent with the fundamental rights. 13 clause 2 talks about the post-constitutional laws, and according to it, the laws which are to be enacted after the coming into operation of the Constitution of India, those post-constitutional laws must also ensure that they remain consistent with the fundamental rights, failing which the laws shall be declared void. Now, Article 13.3 defines law which cannot violate fundamental rights. So it tells us what law means, which cannot violate fundamental right, and this has a special significance, as we'll see later, as to what is included and what is not included under the definition of law under Article 13. A law which is not included as law under Article 13 may even violate fundamental rights, and yet it will remain valid. Whereas a law which is law under Article 13 cannot violate fundamental right, failing which the law itself shall cease to exist. That's a very important practical implication of what is included and what is not included in Article 13. Yeah. This is, for example, Article 13 expressly covers customs under the fold of fundamental right, under the fold of laws which cannot violate fundamental rights. So a custom cannot violate fundamental rights, but an old Bombay High Court judgment in Narasu Appa Mali versus State of Bombay. It's a very old 1951 judgment. The Bombay High Court held that the uncodified personal laws cannot be challenged on the ground that the uncodified personal law violates fundamental right, meaning thereby the uncodified personal laws are not law under Article 2. That's how the implication of what is covered and what is not covered in the definition of law under Article 13 plays out. For a large part of the debate between the legislature and the Supreme Court of India, the debate revolved around, starting from 1950s to 1970s, about the question as to whether a constitutional amendment is law under Article 13 or not. That means whether a constitutional amendment can actually dilute or take away fundamental rights. Because if that constitutional amendment is also law under Article 13, then that constitutional amendment cannot do that. But if a constitutional amendment is not law under Article 13, then the constitutional amendment even possesses the potential of actually taking away some fundamental rights. So that's an important understanding, therefore, so far as inclusion or exclusion of law under Article 13, Clause 3 of the Constitution of India. Now, this is what Article 13 said. This is the literal expression of Article 13. As you can see, Clause 1, pre-constitutional laws, Clause 2, post-constitutional laws, and Clause 3 is actually telling us in our first, in 3A, it is telling us as to what law includes, and it says ordinance, order, bylaws, rule, regulation, notification, custom, or usage having in the territory of India the force of law. So apart from legislations ordinance, order, bylaws, rule, regulation, notification. These are also covered. As you can see, order, bylaw, rule, regulation, and notification. These are actually secondary legislations which are mainly made by the executive, deriving the authority to do so from the primary legislation as enacted by the legislature. Yet even these secondary legislations, order, bylaw, rule, regulation, notification, stands covered under the expression law. Therefore, even through secondary legislations, fundamental right violation has been prohibited. And then clause B of subclause 3 of Article 13, it explains laws in force, and it says it includes laws passed or made by a legislature or competent authorities. So this is actually explaining Article 13, clause 1, pre-constitutional laws. Okay, so if this is how Article 13 has been drafted. Now coming to the provision for writs. As we know, there are 4 kinds of writs: habeas corpus, mandamus, certiorari, prohibition. In fact, there are 5 kinds of writs. I beg your pardon. The 5th one is quo warranto. As we have seen in the earlier slides, that fundamental right enforcement is the task of the High Court and Supreme Court. And the task is performed by the High Court and Supreme Court through directions, orders, or writs. Now, writ is a kind of order, and because of its peculiar history, especially in the United Kingdom, these special set of orders are recognized as writs. So, what are the various kinds of writs? First one is habeas corpus. Now, the primary purpose of the habeas corpus remedy, writ, is to release a person who has been detained unlawfully. Then we have mandamus, where a public official is commanded by the court to perform his or her public duty enshrined in the laws. Then we have certiorari, and which allows the High Court or the Supreme Court to quash the order passed by an inferior court. So this is again an important remedy if there is if what is going on in the lower court, something that may actually be taken as an example which the court ought not to have done, then in that case the superior courts exercising their certiorari right may actually quash the order passed by the inferior court. And then we have prohibition. By this, the High Courts or the Supreme Court may prohibit the lower court from continuing the proceedings. In certiorari, the court can quash the proceedings, and in prohibition, there can be a prohibition stay on the continuance of the proceedings. Quo warranto is actually to stop a person who does not possess the requisite eligibility from holding a public office. And that is why the writ of quo warranto asks the question, where is your authority and with what warrant? So these are some of the important kinds of writs that you should generally remember, because these may actually be asked in the exam, being very common understanding about writs. Now we'll discuss a few passages in order to see and comprehend the various kinds of questions that are asked in the common law admission test. So this is actually from CLAT 2022 examination. The passage in the legal reasoning part reads as follows: writ is a public law remedy. It refers to formal written order issued by a judicial authority directing an individual or authority to do or refrain from doing an act. No, but before I actually read this entire passage, we must know that So far as CLAT legal reasoning part is concerned, it generally accounts for around 25% of the total questions that are asked in CLAT. However, what is important is that if you look at the website of CLAT Consortium, it says that prior knowledge of law is not needed. However, if you look at the nature of the passages which are asked, the explainer of a legal provision is hardly there in a sentence. Therefore, lack of familiarity with that concept may actually be a bottleneck between the students and the student's success. Because the student is not familiar with that concept, the student may find it actually difficult to comprehend it in the examination hall when she is actually reading it for the first time ever. And from those one or two sentences, the student is expected to have understood that concept. And that's why it, on many occasions, would become difficult if the student is not familiar with those concepts even before coming to write the exam. So though technically speaking, the prior knowledge of law is not required, but the prior knowledge of law can actually be very, very handy, as we see. And therefore, in this backdrop, we must see this passage. So writ is a public law remedy. Now imagine if you haven't heard writ, then what sense will you make of this term writ? If you are familiar with writ, you will obviously have no difficulty comprehending this term writ as to how is writ a public law remedy. Okay, so that is how familiarity is important, and that's why prior knowledge of law therefore has to be taken with that correct understanding that though technically speaking it is not required, but familiarity nevertheless is important in order to quickly understand a given passage and solve the questions based on it. So writ is a public law remedy. It refers to a formal written order issued by a judicial authority directing an individual or authority to do or refrain from doing an act. The High Court, while exercising its power of judicial review, does not act as an appellate body. Now, again, if you don't understand what is appellate body, you cannot here understand the distinction between the functions of High Court as a writ ordering, issuing court, and High Court as an appellate court. Okay, so appellate court can even be lower court, but the writ issuing court under the Indian Constitution and the existing laws are only High Courts and Supreme Court. That again is something where the familiarity of a student with the various concepts would go a great deal in making a student quickly comprehend these passages. Okay. Likewise, the power of judicial review. Now, unless you are familiar, what sense do we make of this term judicial review? So, judicial review, as I said while discussing constitutionalism, courts will have the power of reviewing the executive actions legality and the legislative actions constitutionality. Therefore, the courts in India possess the power of reviewing the actions of the executive and the legislature. And this power is what is known as the power of judicial review. So I'll once again start from the beginning because I read these 2-3 sentences only to emphasize how a prior knowledge or the familiarity of a CLAT aspirant with the various legal terms is actually important to enable the aspirant to comprehend the complexities of the passage in the real common law admission test, where apart from understanding, real test is actually how quickly you can understand, because there is always the problem of shortage of time. All that has to be factored, and in this sense, the familiarity of a student with the various legal concepts would come enormously handy. Now, going back to actually reading this passage from the beginning. Writ is a public law remedy. It refers to a formal written order issued by a judicial authority directing an individual or authority to do or refrain from doing an act. As we saw, it is mainly for individual or authority who possesses a legal or a public duty to act or refrain from acting. The High Court, while exercising its power of judicial review, does not act as an appellate body. It is concerned primarily with illegality, irrationality, and procedural impropriety. Okay. Now, what happens in the appellate body and in writ jurisdiction? Appellate body, if the court is functioning like an appellate court, a very detailed inquiry into the facts and circumstances may actually be undertaken by the courts, whereas in writ, that is not done. A very detailed inquiry is not done, and based on the arguments presented from both sides, a decision may actually be taken without actually going into the in-depth analysis or inquiry about the questions raised in the writ jurisdiction. That is an important distinction. So it is concerned with illegality, irrationality, and irrationality, which is reflected on the face of it, and the procedural impropriety of an order passed by the state or a state authority. A procedural impropriety would refer to the fact as to whether an order passed has been passed following the required procedures under the law or not. A High Court is empowered to issue directions, order, or writs for the enforcement of fundamental rights and for any other purpose. This any other purpose, again, is the distinction between Article 32 and 226. Article 32 is limited to the enforcement of fundamental rights, whereas 226 has a broader objective that it can even be invoked for purposes other than the enforcement of fundamental rights. The writ jurisdiction of High Court is discretionary and equitable. Discretionary and equitable. It is said so that it is based on the discretion of the court, whether the court would like to intervene or not. If the court would not like to intervene, then the court cannot be forced to act. Writ of mandamus is issued by a court commanding a public authority to perform a public duty belonging to its office. It can be issued only when a legal duty is imposed on the authority and the petitioner has the right to compel the performance of such duty. Writ of mandamus is required to be issued inter alia to compel performance of mandamus, to compel performance of public duties, which may be administrative, ministerial, or statutory in nature. Writ of mandamus may be issued in favor of precedent. A writ of mandamus may be issued in favor of a person who establishes a legal right in himself. It may be issued against a person who has a mandatory legal duty to perform but has failed or has neglected to do so. Such a legal duty emanates from operation of law. The writ of mandamus is most extensive in regards to its remedial nature. The object of mandamus is to prevent disorder emanating from failure of justice and is required to be granted in all cases where the law has established no specific remedy. Now, based on this passage, we have a few questions that have been asked in the common law admission test in the year 2022. So the first one is the government of a state made a rule to make it discretionary to grant dearness allowance to its employees. One of the employees filed a writ petition seeking a mandamus to compel the government to grant dearness allowance. In the given situation, which of the following statements is true? Writ of mandamus cannot be granted as no legal duty was imposed on the government to grant dearness allowance. The writ of mandamus cannot be granted as the statutory right was enforced on the employee to receive dearness allowance. Writ of mandamus can be granted as it is a public law remedy, and writ of mandamus can be granted as it is a discretionary remedy. Now, if you carefully examine the options here, you will come to the conclusion that option A is correct. Okay, because it says writ of mandamus cannot be granted as no legal duty was imposed on the government to grant dearness allowance. Now, the question makes it clear that it was discretionary to grant dearness allowance to employees. And that's why there was no legal duty to grant dearness allowance. If that be the case, writ of mandamus cannot be issued. Okay. And if you look at clause B, writ of mandamus cannot be granted as statutory right was conferred on the employees to receive. No, there is no statutory right to receive dearness allowance. It remains discretionary, and that is why clause A of the question is actually the correct answer. Public-spirited citizen filed a writ petition seeking a mandamus to compel the government to make a law to curb the ill effects of climate change. In the given situation, which of the following statements is true? Writ of mandamus can be granted. Now, whether it is any public or statutory duty of the government to actually make laws to curb the ill effects of climate change, the answer is no. The government has no public or legal duty, statutory duty to do so. If that is the case, writ of mandamus cannot be granted. Now, only B and D talk about writ of mandamus cannot be granted. Now, if you read further, now writ of mandamus cannot be granted as no legal duty is imposed on the government to pass a law to curb ill effects of climate change. As we discussed, clause B will be the right answer. Okay, because the government does not owe any legal duty to actually pass such a law. Whereas writ of mandamus cannot be granted as there is no violation of fundamental right. Now, the question about fundamental right has not been discussed in the question, and that's why quite clearly clause B is the right answer. Now, coming to the third question, which was numbered 68 in the question paper in the common law admission test. Now, Mr. A and B are parties to a contract of sale of goods. Upon breach of contractual obligation by Mr. A, Mr. B filed a writ petition seeking a mandamus to compel Mr. A to perform his obligations under the contract. In the given situation, which of the following is true? Now, it is quite clear that this is about contractual obligations, and contractual obligations are not statutory or public obligations. So, very clear, writ of mandamus cannot be granted. So, we only have clause B and C, which says writ of mandamus cannot be granted. Now, writ of mandamus cannot be granted as there is no violation of fundamental right, is what B says. And writ of mandamus cannot be granted as Mr. B's right under the contract is a private right. Now, so far as the question is concerned, there is no discussion about the fundamental right, but there is a discussion about contracts, and we know that the contract is a private right. Again, this is something that the prior knowledge and the familiarity with the contract law would come in handy for you to answer this question. We all know that contract would give rise to a private right, and therefore it will not give rise to a public right or a public duty. And therefore, since this is a case of contract, therefore clause C is the right answer. A licensing officer under the is under a statutory duty to issue a license to an applicant who fulfills the conditions prescribed for the issue of such license. Mr. X, an applicant, fulfilled all the conditions prescribed for the issue of such license, but his application for issuance of license was rejected by the licensing officer. In the given situation, which of the following is correct? Now, it's quite clear that if a person has fulfilled all that is to be done in order to get a license from a licensing officer who was performing a statutory duty, then in that case, failure to issue license would give rise to a cause for the writ of mandamus to be issued. So if you look at the options, we have clause A and clause C, which say a mandamus can be granted. Now see further, clause A says writ of mandamus can be granted, compelling the licensing officer to issue the license, and C says writ of mandamus can be granted as it is the discretion of the licensing officer to grant license. In this case, since X has fulfilled all the formalities for the grant of or the issuance of license, it is not the discretion of the licensing officer to grant license, and therefore the license officer is actually to be compelled to issue the license. If we understand this quite clearly, clause A is the right answer. And the fifth question based on this passage. As you can see, the questions are not derived from the passage. The questions are derived from the manner in which the writ of mandamus has been explained. And then based on that understanding, the writ of mandamus logic is being applied to various fact situations for us to actually apply the principle and find the right answer. Which of the following statements is incorrect? Writ of mandamus may be issued in favor of a person who establishes the existence of a legal right. Now appears to be right, but we must rule out the all other options because the best option is the right answer. So now come to clause B. Writ of mandamus may be issued against a person or authority who has a mandatory duty to perform but has failed or has neglected to do so. Now this also appears to be right. Writ of mandamus is purported to prevent disorder emanating from failure of justice. Now this was nowhere mentioned in the passage. Another important thing that we have to keep in mind that your prior knowledge or familiarity with a particular legal concept may actually mean that you know more than what the passage is actually telling you. But we must keep in mind that your answers are to be derived from the passage, and therefore you should not be supplying additional information on that concept from based on your reading or familiarity of that concept. So clause C, writ of mandamus is purported to prevent disorder emanating from failure of justice. This may actually be true, but so far as the passage is concerned, there is nothing of this sort written in the passage. So therefore, we will rule out clause C as incorrect. Writ of mandamus may be requested to be issued to compel performance of a private duty, which may be administrative, ministerial, or statutory in nature. Again, quite clearly, writ of mandamus is not issued for private duties. So if we go by option A, B, C, D, C and D appears to be incorrect statements. Okay. So the option which would say option C and D is correct, is actually incorrect. That option is the correct answer. Now, moving on to another passage. This is actually based on fundamental rights. But before that, we will discuss a few fundamental rights, because as I started, I did not discuss with you the specific fundamental rights. So we'll first discuss some of those specific fundamental rights, especially Article 14, 19, 21, and 25. And then we will see the specific passages based on those specific fundamental rights. And then we'll answer the questions that have been asked or may be asked from the passages in the legal reasoning chapter. So far as the first module to Introduction to Constitutional Law for the CLAT preparation is concerned, that is it. I'll see you in the next video. Thank you very much.